He also did not plan who was going to manage these assets for the benefit of his son, who is his intestate heir. This child is 8 years old. He's not going to manage his own assets. He, cognitively can't, and legally he can't until he's 18 in California. You have to be 18. So a guardian has to be appointed, or a court has to create a trust for his benefit. Once he turns 18, he gets the money. In California, he would get that $32 million when he turned 18, or whatever's left of it by that time. So by dying intestate, Liam Payne did not choose who was going to be managing his son's money for the next 10 years. Who ends up managing it is his ex-girlfriend, who is the mother of the child, plus a music industry lawyer. They're going to work together on managing that money for the son. But Liam Payne didn't choose those people. Maybe he would have chosen them, but maybe he wouldn't. He didn't have a chance. Also, the 18 years old, very few parents, and I'm going to say in my practice of, a lot of years, I can probably come up with just one handful of parents who said to me, oh yeah, I think 18 years old is perfectly fine to inherit a whole bunch of money. The vast majority of my clients would say 18 is too young. Let's maybe wait till 25 or something like that. So this child's going to get $32 million or whatever left of it at the age of 18. And, we'll see what happens there. Also, by not planning for this inheritance for his child, he didn't leave anything to anybody else because this child is his intestate heir. This child gets all of it. This Liam Payne was a young man. He is survived by both his parents. He has 2 siblings, I think I read. I would guess that given the size of his estate, he might have wanted to be generous with other family members. And especially when you think about an 18-year-old getting $32 million, no 18-year-old needs that much money. It would have been prudent from a lot of perspectives to spread the money around a little bit. And he's also got the girlfriend that we mentioned who lived in his home. I don't know that it was his home. I'm just assuming because he's got $32 million that he owned the home that they lived in together. And as an executor of this estate, you owe a duty to the beneficiary of the estate, which is the child, not the girlfriend who lives there. So legally, the girlfriend either has to leave or has to start paying rent if she's going to stay there. So that's a whole thing that he probably wouldn't have wanted. He wouldn't have wanted his girlfriend thrown out the day after he died. If he had written an estate plan, he could have planned for all of that. And perhaps he would have wanted to leave something to her too. So a whole lot of things went wrong here because he did not have a written estate plan, not the least of which also is taxes. In the U.S., a $32 million estate would be subject to estate tax. There would be, close to $20 million in excess estate, probably $18 million, subject to a 40% estate tax.